W. Duffley, Commissioner of the North Carolina Utilities Commission and presiding commissioner of this hearing. With me today are Chair Charlotte A. Mitchell, Commissioners Tanola D. Brown Bland, Daniel G. Clodfelter, Floyd B. McKissick Jr., Jeffrey A. Hughes, and Karen M. Kimmerite. I now call for hearing docket E-7 sub 1276, which is the application of Duke Energy Carolinas, or DEC, for adjustment of rates and charges applicable to electric service in North Carolina, and docket number E-7 sub 1134, which concerns DEC's petition to amend its Certificate of Public Convenience and Necessity for a 402 megawatt combustion turbine at its existing Lincoln County combustion turbine site in Lincoln County, North Carolina. The Commission consolidated these two dockets by order dated July 11th, 2023. As I'm required to do by the State Government Ethics Act, I remind all members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has a known conflict with respect to the matters coming before us in this proceeding. Let the record reflect that no conflicts have been identified, so we will proceed. In late 2021, legislation authorizing the performance-based regulation of electric public utilities operating in North Carolina was enacted by the General Assembly and signed into law by the governor. This legislation, which has now been codified as Section 62-133.16 of the North Carolina General Statutes, establishes an alternative rate-making approach that, among other things, expands upon the traditional historic test year method of setting rates set forth in Section 62-133 of the General Statutes, and authorizes the setting of rates based on a multi-year projection of costs. Section 62-133.16 requires that an application to use this alternative rate-making approach include a decoupling rate-making mechanism, one or more performance incentive mechanisms, and a multi-year rate plan, including an earnings sharing mechanism and proposed revenue requirements and base rates for each of the years that the multi-year plan is in effect. The Commission adopted Rule R1-17B to implement the requirements of this statute. On September 8, 2022, in accordance with Rule R1-17B, DEC filed its request that the Commission initiate a technical conference regarding the projected transmission and distribution projects to be included in the company's impending application. In response, the Commission opened docket E-7 sub 1276. On September 12th and 13th, 2022, DEC, Public Staff, and SIGFER caused to be filed in this docket an agreement and stipulation of partial settlement regarding the methodology for allocating production and transmission demand-related costs. On November 2nd, 2022, the Commission held the technical conference. On January 19, 2023, DEC filed its application to adjust retail base rates and for performance-based regulation, as well as a request for an accounting order, along with the direct testimony and exhibits of 25 witnesses supporting the application. In its application, DEC requests authority to increase its rates and charges to produce additional overall annual North Carolina base revenues of approximately $833.2 million. DEC seeks approval from the Commission to implement for the first time performance-based regulation with this company with a 3-year rate plan. DEC has requested the approval of a residential decoupling mechanism, an earnings sharing mechanism, and a performance incentive mechanism. On February 16, 2023, the Commission issued an order establishing a general rate case and suspending rates. And on March 16th, 2023, the Commission issued an order scheduling investigation and hearings, establishing intervention and testimony due dates and discovery guidelines, and requiring public notice. As reflected in the March 16, 2023 scheduling order, DEC's request includes a general base rate increase as well as increases over each of the 3 years for a total increase in base revenues of approximately 16.7%. Broken down by year, DEC requests an increase of approximately 7.4% to general base rate revenues, plus an additional 2.8% in rate year 1, 3.4% in rate year 2, and 3.3% in rate year 3. The March 16, 2023 order scheduled an expert witness hearing beginning at 2 p.m. on Monday, August 21st, 2023, and continuing as necessary until its conclusion, and scheduled several public witness hearings. The order also required that DEC provide notice of its request to increase rates to customers by bill or insert and by newspaper publication. Subsequently, on July 26, 2023, the Commission issued an order rescheduling the expert witness hearing to begin at 2 p.m. today, Monday, August 28, 2023. On April 27, 2023, DEC filed the Transmission Cost Allocation Agreement and Stipulation of Settlement, which it entered into with the public staff. On May 4, 2023, DEC filed an agreement and stipulation of partial settlement regarding the Low-Income Affordability Performance Incentive Mechanism and affordability issues, which it entered into with the Sierra Club, the North Carolina Justice Center, the North Carolina Housing Coalition, the Natural Resources Defense Council, the Southern Alliance for Clean Energy, Vote Solar, and the public staff. On May 19th, June 19th, and July 18th, 2023, DEC made supplemental filings. In late June, July, and August, the Commission held public witness hearings in Morganton, Winston-Salem, Charlotte, and Durham, and conducted 2 public witness hearings virtually for the purpose of receiving testimony from DEC's customers regarding the proposed rate increase. Formal parties to this proceeding are numerous. The public staff, which represents the using and consuming public, has been made a party to this case pursuant to North Carolina General Statute Section 62-15. The Attorney General's Office has intervened in this case in accordance with North Carolina General Statute Section 62-20. In addition, the following parties have petitioned and have been allowed to intervene in this proceeding: the Carolina Industrial Group for Fair Utility Rates 3 or SIGFR 3, Haywood EMC, Blue Ridge EMC, Rutherfordton EMC, Piedmont EMC, the North Carolina Sustainable Energy Association, the North Carolina Justice Center, NCJC, the North Carolina Housing Coalition, the Southern Alliance for Clean Energy, and the Natural Resources Defense Council, collectively appearing as NCJC et al., the Carolina Utility Customers Association Incorporated, or KUCA, the Commercial Group, the Sierra Club, Vote Solar, the Kroger Company, and Harris Teeter LLC, a division of the Kroger Company, collectively Kroger, the Carolinas Clean Energy Business Association, Andel LLC, NC Warren, and the North Carolina League of Municipalities. On July 19th, 2023, the public staff, the AGO, and the other intervening parties filed testimony and exhibits of their witnesses. On August 4th, 2023, DEC filed rebuttal testimony and exhibits for 25 of its witnesses, some of which contain confidential information. On August 7th, 2023, DEC filed the affidavits of publication and a notice seeking to implement temporary rates subject to refund. On August 14th, 2023, the Commission issued an order approving the public notice of temporary rates subject to refund and financial undertaking. Also on August 14th, 2023, DEC filed the witness list and a joint motion to excuse witnesses. Said motion was granted. On August 18th, 2023, DEC filed their revised tariffs implementing temporary rates in accordance with the Commission's August 14th order. On August 22nd, 2023, an agreement and stipulation between DEC, the public staff, and SIGFR 3 was filed regarding performance incentive mechanisms, tracking metrics, and the decoupling mechanism. Also on August 22nd, 2023, DEC filed an agreement and stipulation of settlement between DEC and SIGFR 3 regarding power quality. Also on August 22nd, 2023, DEC filed an agreement and stipulation of partial settlement between DEC and public staff regarding the revenue requirement. On August 24th, 2023, DEC and the public staff filed testimony supporting the settlements. On August 25th, 2023, DEC filed the agreement and stipulation of partial settlement between DEC, the commercial group, Kroger Company, and Harris Teeter, LLC, relating to certain rate design issues. On August 25th, 2023, DEC filed settlement testimony supporting the rate design agreement. On the same date, SIGFR 3 filed a motion for admission of certain evidence, which I believe brings us to today. I believe there were some filings as well today, which can be updated. And I now call on council for the parties to announce their appearances, beginning with the applicant.
Thank you very much. Good afternoon, Presiding Commissioner Duffley, Chair Mitchell, and Commissioners. Jack Durack here on behalf of Duke Energy Carolinas. I'm joined at the council table this time by Karan Mehta and Melissa Butler, law firm of Troutman Pepper. And we'll have a number of other attorneys making appearances at various points of this proceeding to represent various of our witnesses. Thank you very much.
Good afternoon. Public staff.
Nadia Moore, to public staff on behalf of the using and consuming public, and appearing with me are Robert Josie, Lucy Edmondson, Steve Creech, Ann Keyworth, Will Freeman, and Tom Fallon.
Good afternoon.
Derek Mertz with the Attorney General's Office. Appearing with me is Carol Moore. We are here on behalf of the state and the people of North Carolina.
Good afternoon, Mr. Mertz.
Good afternoon. Marcus Trathon of the law firm of Brooks Pierce, appearing on behalf of CUCA. Also, my colleagues Matt Tynan and Christopher Dodd will be appearing for CUCA. I'd also like to note that I'm making an appearance for Andel LLC.
Okay, good afternoon.
Good afternoon, Presiding Commissioner Duffley. Christina Kress with the law firm of Bailey and Dixon LLP here in Raleigh, appearing on behalf of SIGFR 3, Haywood EMC, Blue Ridge EMC, Piedmont EMC, and Rutherford EMC. I am joined by my colleague Douglas DC Conant, who will also be appearing on behalf of SIGFR 3. In addition, another colleague, Chris Edwards with the law firm of Ward & Smith, has entered a notice of appearance on behalf of both SIGFR 3 and Blue Ridge EMC et al. Thank you.
Thank you.
Good afternoon, Commissioner. Ben Snowden with the law firm of Fox Rothschild LLP here on behalf of the North Carolina League of Municipalities.
Good afternoon.
Good afternoon, Ethan Blumenthal, appearing on behalf of the North Carolina Sustainable Energy Association.
Good afternoon to you, sir.
Commissioner Alan Jenkins for the commercial group.
Good afternoon, Mr. Jenkins.
Good afternoon, David Neal with the Southern Environmental Law Center on behalf of MCJC et al. And Vote Solar. We would ask that Vote Solar be included in the MCJC et al. Designation. With me is Bonaccia Margarira, and Thomas Gooding will also be making appearance.
Thank you. Good afternoon.
Good afternoon, Kurt Bain, appearing on behalf of the Kroger Company and Harris Teeter LLC. I'd also like to enter the appearances of Jody Kyler Cohn and Ben Royston.
Thank you.
I'm Carolyn Becker, appearing on behalf of the Sierra Club, and also appearing with me will be attorney Catherine Polly Jones.
Good afternoon.
Good afternoon, Commissioners. Matthew Quinn. I'm with the law firm of Lewis and Roberts, and I'm here on behalf of NC Morin. Thank you.
Good afternoon, Mr. Quinn. Are there any other people that want to introduce themselves? Okay, so let's now take up preliminary matters.
Thank you, Commissioner Duffley. So at this time, DEC is prepared to move into the record a number of stipulations, all of which you mentioned in the introduction for this hearing. I believe there's also pending motions related to the potential admission of portions of the DEP evidentiary record into the DEC record. I think it might make sense to take those up first if there's any matters to be heard on those topics specifically.
I think that's a good idea to take up those motions first. And I do know that we had another filing today. So first we'll hear from Ms. Kress
Thank
on
you.
her motion.
Thank you, Commissioner Duffley. I did file in the docket on Friday a motion for admission of certain evidence, and in that motion, we set forth a number of supporting details as well as an index of potential transcript excerpts from the Duke Energy Progress rate case that was heard by the Commission in May of 2023 and then again in July for a portion that was reconvened. I did want to note that over the weekend, the company pointed out one correction to the transcript sites that were included in the index filed with SIGFR's motion. That is with respect to the Bowman and Quick panel, which should be transcript volume 7, pages 114 to 182, rather than 26 to 182. And if it would be helpful, we did bring along with us today 3 copies of the transcript excerpts, and we have pulled out the pages that the company brought to our attention as being pre-filed testimony, which we did not intend to include in the sites that were provided to the Commission. So we do have those and happy to provide them if that would be helpful. And finally, just a point of clarification, there were 2 parties who did not object, and they were indicated as such. But they did want to clarify that by not objecting to SIGFR's motion, they are not necessarily consenting to the excusal of the witnesses listed in SIGFR's motion.
And who are those 2 parties, if you'll remind me?
CUCA and Andel, who can of course speak for themselves, but I did want to make sure that I mentioned that.
Okay, thank you. And I believe that I think that the AGO wanted to be heard on this matter as well as DEC. Am I correct?
On this particular motion, we're given the opportunity to review the transcript sites that were requested for admission, and as Ms. Kress noted, we worked out 1 or 2 issues in there, and with those changes, we are not objecting to the admission of those portions of the transcript into the DEC record.
Okay, thank you. And Mr. Mertz?
We're able to review over the week additional transcript pages, specifically with regard to Attorney General's witness that testified in the DEC.
Okay, thank you. The commission does have some questions for you. And specifically, and sorry, we're having some technical difficulties up here with our connections. So Ms. Kress, I'd like to understand exactly what SIGFR is requesting. And if you could help me and walk me through it. Are you requesting that the live testimony from the DEP case be treated as testimony in this case, and barring any facts specific to DEP, the commission will treat this testimony and the exhibit transcripts as testimony in this case? Meaning, would you want the court reporter, how's it going to work? Would you want the court reporter to drop it into the transcript, the identified testimony similar to how pre-filed testimony is treated in the transcript? Or are you asking for something less? As on page 5, section 8 of the motion, it states the commission may rely on and determine the appropriate weight to be given to any DEP admitted evidence that involves common information. So that seems something less. So could you clarify this for me?
Sure, and I'm looking to the public staff and DEC and other interveners as well, because I want to make sure that I'm not representing something that is inconsistent with the relief being requested in the motion. And certainly other parties can speak for themselves, but SIGFR 3 would like for this evidence to be considered by the commission as, for the truth of the matter asserted. So in other words, as evidence that the commission could rely upon in making its decisions in this rate case. And so, in my mind, what that looks like is being inserted into the transcript of the DEC evidentiary record.
Okay, and the commission has some concerns. When we've done this before on the back end, it causes additional work and confusion. So especially with DE specific numbers and testimony that's specific to DEP, what's your response to that? I mean, what percentage of the pages are so DEP specific or have DEP numbers that it will cause such confusion?
In my opinion, the issues that we were able to narrow down for the commission's consideration, which really is 3 sort of discrete issues and groupings of witnesses here in this motion, SIGFR 3 believes that there is a sufficient amount of overlap and similarity between the testimony provided in the DEP rate case that would be equally applicable to the DEC rate case, that it would help to streamline the hearing and certainly minimize the necessity of having to rehash or retread old ground that would be substantially identical in this rate case as it was, when the case was first presented to the commission back in May in the DEP rate case.
And if the commission were to deny this motion, do you believe that you'll be able to pare down your cross-examination now that you have the DEP order?
So unfortunately, no, because it is also about preserving a record. And so in order to preserve a record, we either need to have that evidence come into the record in this rate case through this motion or through live testimony in this rate case.
Okay, thank you for that. And does anyone else want to be heard on this motion?
If I may,
Mhm.
I think I would say that generally all the parties, there was a general recognition among all the parties that there would be some benefit to identifying ways in which to streamline this proceeding. And one of those ways was seeking to identify portions of the DEP transcript that would have general applicability to the DEC proceeding. And ultimately, those conversations amongst parties resulted in the 2 motions before you. From our perspective, the relatively narrow nature of the transcript portions that are sought for admission make them such that it would be reasonable to place those in the DEC transcript for purposes of making this proceeding more efficient. And I would agree with Ms. Kress' characterization. In general, the vast majority of those portions involve testimony that is generally applicable to both the DEP and the DEC proceeding. And the caveat included in the motion is just to capture any miscellaneous smaller matters that are DEP specific in that. But I'd say the majority of it is broadly applicable enough to warrant inclusion in the DEC transcript. And we've worked again with the parties to try to get that right and get the right balance in terms of the exact excerpts that are going to be admitted and that are before you for consideration for admission into the DEC record.
Okay, thank you for this. And I'm not going to rule on the motion. We have the one panel today that you're going to need to do your full cross on. And I should have a ruling tonight or tomorrow morning on that motion. And I see, let's see, Mr. Neal, you have presented a motion, the NCJC motion. Would you like to present that motion?
Commissioner Duffy, I don't have a lot to add. I think Ms. Kress has articulated and Mr. Drack have articulated the reasons why it would be beneficial to grant the motion. We did note in our motion there's some overlap and because there wasn't one broad motion and that we would certainly, if the commission is willing to grant the motions, we would work to make sure we didn't have duplicate materials submitted. And I think the caveat that we noted in our motion, I believe that is also in Sigfur's motion, that we have faith that the commission can give it the appropriate weight in rendering its decision to the extent that there were any particular, DEP particular matters, but we think we've done a good job of identifying issues in common from witnesses in common and will really help us streamline this hearing. Thank you.
Okay, thank you. Does anyone else want to be heard on the NCJC motion? Okay, thank you. So next we'll move back to Mr. Drack.
Yeah. Thank you, Commissioner Duffy. At this time, we were going to move in a series of documents and filings similar in approach to the one we took in the DEP proceeding. So we'll start with the company's transmission and distribution informational filing made on October 19th, 2022. We'd like to move that in the record along with the company's application and E1s that were filed with the commission on January 19th, 2023. We'd ask that those would be accepted in the record and copied in the record at the appropriate time.
Okay, without objection, that motion is approved and the transmission and distribution filing dated October 19th, 2022 will be made part of the record, and the application filed on January 19th, 2023, consisting of 24 pages, 2 appendices, and 12 exhibits, without objection, will be moved into the record.
Thank you very much. We would like to now move into the record a number of stipulations that were reached in this proceeding, and you referenced those again in your introduction. And as we do that, we want to begin by, of course, acknowledging the good faith engagement of all parties to find areas of consensus in this case, as well as the opportunities to streamline the efficiency of this proceeding. And we sincerely appreciate all the efforts that went into these. For purposes of walking through these stipulations, if it would be all right with you, we have just now filed, and we have a few extra hard copies. I know the commission has a few extra copies, has copies themselves of this document. This overview document is a table that we've set up to allow all parties in the commission a chance to see all the stipulations in one place, see when they were filed, and also tie out the testimony to the various pieces of supporting settlement testimony that have also been entered in this docket. So as I walk through these for purposes of moving these into the record, it might be helpful to have this document in front of the commission as well as parties. We have a few extra hard copies, and it's also now available on the commission's docket. In general, as I walk through these, I will try to use the same name that was given to these documents, the equivalent version of these documents in the DEP rate case order, so that we can help commission and parties to orient to what has been filed. So starting from the beginning, we at this time would like to move into the record the initial revenue requirement settlement that was filed on August 22nd, 2023, and it was an agreement executed with public staff. I'll now go on to the next related document as well. So as we notified all parties on Friday, and then have filed today. That revenue requirement stipulation was amended as between the company and the public staff. And the changes to that agreement were to just move more of the unresolved issues into the resolved issue category of the agreement. So that second stipulation we're going to refer to as the amended revenue requirement stipulation was filed today in the docket. Parties to that agreement are DEC and public staff.
So, Mr. Dirac, I hear you moving into the record, making a motion to move into the record. The initial revenue requirement stipulation filed on August 22nd, 2023 by DEC. It's between DEC and the public staff, and that motion will be allowed. And Mr. Dirac has also made a motion to move into the record the amended partial revenue requirement stipulation filed on August 28th, 2023, the parties being DEC and the public staff, and that motion is allowed without objection.
Thank you very much. Moving along, the next stipulation that I would like to move in the record is the PIMS stipulation. This is a stipulation between the public staff, SIGFR 3, and it was filed on August 22nd, 2023, and it covers issues related to performance incentive mechanisms, tracking metrics, and the decoupling mechanism. An equivalent stipulation was filed in the DEP proceeding. This is a DEC specific version of that stipulation. It's the same, similar in scope and substance with some modifications that are DEC specific. So at this time, we would move the PIMS stipulation into the record.
And without objection, that motion is allowed, and the PIMS stipulation filed on August 22nd, 2023, with the parties being DEC, public staff, and SIGFR number 3 is admitted into the record.
Thank you very much. Next, we would like to move into the record the affordability stipulation. This was an agreement reached among DEP, DEC, Sierra Club, the North Carolina Justice Center, the North Carolina Housing Coalition, the Natural Resources Defense Council, the Southern Alliance for Clean Energy, and Vote Solar. This document is identical. When it was executed in the context of the DEP proceeding, it was filed in both dockets as a settlement of those same issues in an identical manner in both dockets, and it was filed into the DEC docket on May 4th, 2023. So we'd like to move that stipulation in the record as well.
Okay, without objection, the affordability stipulation between DEC, DEP, the public staff, and NCJC et al. Were there any other parties?
I believe that is it.
Okay, filed on May 4th, 2023, will be accepted into the record.
Thank you very much. Next up would be the transmission cost allocation stipulation, or the TCA stipulation. Similar to the affordability stipulation, this stipulation is the identical agreement that was entered into the DEP record. It was filed with the commission on April 27th, 2023. The parties to that agreement are DEC, DEP, and the public staff. And so we move that TCA stipulation into the record.
And without objection, the motion to introduce into the evidence the TCA stipulation between DEC, DEP, and the public staff filed on April 27th, 2023 will be allowed.
Thank you very much. Next up, Chair Commissioner Duffley, if I could, I'll move two related stipulations in the record at the same time. These are partial rate design stipulations. They are similar in substance and scope to the equivalent partial rate design stipulations that were entered into the record in the DEP proceeding. In the DEP proceeding, they were referred to as the MGS partial rate design stipulation and the LGS partial rate design stipulation. Unfortunately, the tariffs have different names in this proceeding, so we have updated those tariffs and made similar changes as well as a few others. But those stipulations are in general the same concepts as were reflected in the stipulations I referenced. So with that introduction at this time, I would like to move into the record. And again, I apologize to the court reporter for this mouthful. The OPT-V secondary partial rate design stipulation. The parties to that agreement are DEC, the Commercial Group, Kroger Company, and Harris Teeter LLC. I would also like to move into the record the OPT-V primary partial rate design stipulation. The parties to that agreement being DEC and SIGFR 3, and both of those stipulations being filed with the Commission on August 25th, 2023.
Without objection, DEC's motion to introduce into the record the OPT-V secondary partial rate design stipulation entered into between DEC Commercial Group, Kroger Company, Harris Teeter LLC, filed on August 25th, 2023, and the OPT-V primary partial rate design stipulation between DEC and SIGFR 3, also filed on August 25th, 2023, is allowed.
Thank you very much. Just two more to go. Next up is the COSS stipulation, also known as the cost of service stipulation. This stipulation is identical to the one that was entered into the record in the DEP proceeding. And the parties to this agreement are DEC, DEP, Public Staff, SIGFR 2, and SIGFR 3. This stipulation was filed with the Commission on September 12th, 2022, with a slightly revised version with the exhibits attached was filed on September 13th, 2022. So with the Commission's leave, we would move the COSS stipulation into the DEC record.
DEC's motion to introduce into the evidence cost of service stipulation as revised to include exhibits filed between DEC, DEP, Public Staff, SIGFR 2, and SIGFR 3 being the parties, was filed on September 12th, 2022, and revised on September 13th, 2022 is allowed.
Thank you very much. And the last stipulation to be moved in the record is the power quality stipulation. This stipulation was filed with the Commission on August 22nd, 2023. Parties to the agreement are DEC and SIGFR 3. And this agreement has similarities with the power quality stipulation that was entered into the record in the DEP proceeding, but in reflection of the Commission's DEP rate case order, takes a different approach to that and commits to work with SIGFR to develop a future filing responsive to the Commission's concerns in the DEP rate case order. So with the Commission's leave, we would move that the power quality stipulation into the record as well.
DEC's motion to enter into the record the power quality stipulation between DEC and SIGFR 3 filed on August 22nd, 2023 is allowed without objection.
Thank you very much. And once again, DEC expresses its appreciation for all of the efforts of many parties that went into achieving these stipulations. Those are all the procedural matters that we have at this time.
Okay, are there any other preliminary matters before we begin, such as motions to excuse? We will, with the ones that have been filed, we will issue a written order. Are there any oral motions to excuse at this time? Okay.
I would just note that obviously a number of motions have been filed. We will be working with parties in light of the further amended stipulation as well as other matters that occurred here, including potentially Commission's action on the evidentiary motions. We anticipate having a few more witnesses that we may seek for excusal or clear with parties and then seek for excusable. We'll bring those to your attention tomorrow if that's all right.
Okay, thank you, Mr. Jarak. Well, we will proceed, and Duke, the case is with you. You may call your first witness.
Thank you very much. At this time, Commissioner Duffley, we would call to stand Ms. Kendall Bowman and Ms. Leslie Quick.
Left hand on the Bible? Or wait, right hand on the Bible? Wait, no, it's left. Raise right hand, left hand on the Bible. Close to your heart, left, right. Do you solemnly swear that the testimony you're going to provide here today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Ms. Bowman, would you please state your name and business address for the record?
Kendall C. Bowman, 410 South Wilmington Street, Raleigh, North Carolina, 27601.
Thank you. And by whom are you employed and in what capacity?
Duke Energy, and I'm the Duke Energy president for North Carolina.
Ms. Bowman, on January 19th, 2023, did you cause to be pre-filed in this docket direct testimony consisting of 27 pages?
Yes.
And did you also, on August 24th, 23, cause to be pre-filed in this docket settlement supporting testimony consisting of 6 pages?
Yes.
And did you also, on August 28th, 2023, cause to be pre-filed in this docket supplemental settlement supporting testimony consisting of 6 pages?
Yes.
And hold on, if I may have one moment. And to back up one moment, did you also cause to be filed rebuttal testimony in this docket on August 4th as well?
I did.
Thank you. Do you have any changes or corrections to your pre-filed direct or rebuttal or supplemental settlement testimony?
I do not.
If I were to ask you the same questions today under oath, would your answers be the same as are set forth in that pre-filed testimony?
Yes.
Commissioner Duffley, at this time, I would ask that Ms. Bowman's pre-filed direct, rebuttal, settlement testimony, and supplemental settlement testimony be entered in the record as if given orally here today.
That motion is allowed.
Turning now to Ms. Quick, will you please state your name and a business address for the record?
Leslie Quick, 525 South Tryon Street, Charlotte, North Carolina.
Thank you. And by whom are you employed and in what capacity?
Duke Energy, I'm the Vice President of Customer Technology, Regulatory Advocacy, and Business Support.
Ms. Quick, on January 19th, 2023, did you cause to be pre-filed in this docket direct testimony consisting of 50 pages and 1 exhibit?
Yes.
And have you submitted to the commission any changes to your pre-filed direct testimony?
Yes, I did, and those have already been filed.
Thank you. And with that correction, if I were to ask you the same questions today under oath, would your answers be the same as are set forth in that pre-filed direct testimony?
Yes.
Commissioner Duffley, at this time, I would ask that Ms. Quick's pre-filed direct testimony and her exhibit be entered into the record as given orally here today.
The direct testimony of Ms. Quick filed on January 19th, 2023, consisting of 50 pages, will be copied into the record as if given orally from the stand, and the exhibit that was filed on January 19th, 2023, and corrected on August 24th, 2023, will be marked for identification as it was when pre-filed.
Thank you very much. The witnesses are now available for cross-examination.
Commissioner Duffley, if I may clarify, on the witness list, Ms. Bowman is listed as having a separate rebuttal testimony, and so coming back during the company's rebuttal case to take the stand again. But I heard Mr. Jurack introduce her rebuttal testimony this afternoon, excuse me. And so I just want to be clear and make sure that something hasn't changed last minute with the witness list and presentation of the company's case.
Mr. Jurack?
We are prepared this afternoon to offer the entirety of Ms. Bowman's rebuttal testimony. I understand, though, that the witness list shows it as just direct and settlement testimony at this time. So if parties would request, we can hold on the rebuttal testimony until the rebuttal phase of the proceeding.
Response?
In the interest of time, SIGFR 3 would prefer to have the commission's ruling on its pending motion before agreeing to move forward with Ms. Bowman's rebuttal case this afternoon. And so we would object to that last minute change in the witness list and order of evidence.
Okay, any other parties wish to be heard?
Yeah, this is Nadia Lore with the public staff. We would also request that the rebuttal testimony be presented separately.
Okay, so I will rule on that. We will just be crossing on Ms. Bowman's direct testimony at this time, and we will have Ms. Bowman come back for rebuttal testimony.
Thank you. SIGFR has no questions for this panel.
Good afternoon. I'm Marcus Trathan for CUCA. Just have a few questions of a general nature, and Ms. Bowman, I believe that they're all directed at you. Duke supported House Bill 951, correct?
Yes, we participated in the stakeholder process for House Bill 951.
And you worked hard to secure its passage, correct?
We believed it was in the best interest and good policy for the state of North Carolina.
And the multi-year rate plan aspect of that bill was an important component of that to Duke, correct?
Yes, we believe that modernization of the rate making in North Carolina in order to help us on our clean energy transition was needed.
Okay, just want to ask you a few questions about rate affordability from an industrial perspective in particular. I know this is an important issue for Duke. I don't want my questions to be taken to imply otherwise. On February 28 of this year, DEC filed an application for a fuel rider adjustment seeking collection of $1 billion fuel charge under collection. Is that right?
That is correct.
And that application, as filed, would have resulted in an 18% average rate increase across retail customers, correct?
I believe it was just a shy lower of the 18%, but as it was filed, that is not what ended up being approved.
And the commission ultimately approved a settlement which was agreed to by Duke, which will result in about a 13% increase, average increase for retail customers. Is that right?
So, subject to check. Yes, we agreed to some rate mitigations to help to defray that.
Okay. Now, while the rider application was filed after your general rate case filing here, Duke knew about the magnitude of the undercollection when it filed its application in this proceeding, didn't it?
Yes, gas prices increased significantly in the past year across the entire country. So everyone was experiencing higher fuel prices, so we were aware.
So if the commission approves a rate increase in this case, it'll be on top of the already average 13% rate increase, correct?
It will be in conjunction with that fuel rate increase, but fuel rates change year over year. That is not constant. We believe that projections, I believe gas prices are continuing to go down, so that impact may go down. So it's only for the next year.
Okay. And from the industrial perspective, do you acknowledge that what appear to be modest rate adjustments can have a dramatic rate impact for large users like industrial customers?
Yes, we understand that at Duke Energy, and we continue to work with our large industrial customers to figure out ways to mitigate that via specific rate design. And we also worked on a equal fuel plan to help reduce those spikes for our large industrial customers.
And you agree that many industrial customers compete in a global environment?
Yes, we realize that they compete in a global environment, and that sometimes energy, among other things, are very important to their bottom line. And that's why, again, we strive to work with our customers, and we strive to have competitive rates in North Carolina. Even with this proposed rate increase, we're still below the national average. And I believe North Carolina has been ranked the second year in the row as one of the top places to do business.
Yes, it is. And would you agree that ensuring an environment where rates are reasonable, competitive, and predictable are critical to jobs and investment for the state?
Yes, we believe that providing reliable and affordable energy is critical to the economy of North Carolina.
And are you aware the CUCA has proposed in this case a competitiveness PIM to incent Duke to ensure that its rates are regionally competitive?
I am generally aware, but not familiar. I would defer any specific questions to the PIM's witnesses.
Certainly. So one of the issues in this case involves the accounting treatment for coal facilities that DEC will retire early, correct?
That is correct.
And Duke is proposing to defer certain costs so that ratepayers can receive the benefit of securitization of these costs in the future?
In the future, these questions might be more applicable to Ms. Bateman.
Well, feel free to defer, but I've very general questions in nature and see if you can help me here. Am I correct that Duke supports securitization of coal retirement costs where securitization will provide ratepayer benefits?
I believe that there's a provision in House Bill 951 for securitizing coal facilities, and Duke Energy supports that.
Okay. And are you aware with respect to that provision that in the rulemaking before this commission, virtually every party other than Duke raised concerns whether House Bill 951 provided sufficient statutory authority to make coal retirement bonds marketable?
I am aware that that issue was raised.
And my question is, can you provide any insight as to what Duke may be doing to address those concerns?
Chair Duffy, Commissioner Duffy, if I may, I would object to further questions on this topic. We're asking questions about rulemaking proceeding that is separate from this docket and not before the commission at this time in this proceeding.
Mr. Tratham?
Yes, one of Duke's proposals in this case is to to defer certain costs so that they may be securitized in the future. I'm simply asking how we can ensure that that option is available to us in the future.
Overruled. I'm going to provide you a short leash, Mr. Tratham.
Please don't make me repeat that question. It was a long one.
So as I said before, Duke Energy is supportive of securitization. If the current law has a flaw and does not allow that, I think Duke Energy would be supportive of making an adjustment to ensure securitization as it benefits the customers in North Carolina.
Okay, but in terms of any update on what may have been done to date to address that concern, do you have anything to offer?
I am not aware.
Okay. Lastly, Winter Storm Elliott. There are multiple issues resulting in the events of Christmas Eve of last year. Would you agree that Duke's performance is relevant to the commission's determination in this proceeding?
Can you expand on, you say multiple issues? What are you referring to?
I'm sorry. I'm just referring to the Christmas Eve events that resulted in load shed from Winter Storm Elliott. You familiar with that?
I am familiar with that, very familiar with that.
All right. So my question is, do you agree that Duke's performance, including events such as load shedding, are relevant to the commission's determinations in this proceeding?
The commission is to look at our overall service quality and reliability as they are determining this proceeding.
Okay. And here's a real specific question. Aside from issues directly related to the cold weather event, in other words, generation not coming on board that evening because of the cold weather event, do you know approximately how many megawatts of generation capacity were unavailable to Duke on December 24th?
I do not have the answer off the top of my head.
Okay. Do you have a range of what that was?
Your question was?
The amount of capacity, generation capacity that was unavailable to Duke on December 24th, not resulting directly from the cold weather event itself.
When you say not resulting directly from the cold weather event itself, do you mean the derates that happened at
Yes.
particular units?
Yes.
I am not the expert on that. I don't want to gander a number without checking.
Yeah, fair. That's all I have. Thank you.
Yep, good afternoon. Matthew Quinn here with NC Warren. I believe we reserved some cross-examination time for the panel, but in light of some of Mr. Tratham's questions, we will waive cross now. Thank you very much.
Public staff?
Just a few. Good afternoon, Ms. Bowman, Ms. Quick. My name is Robert Josie. I'm with the public staff. Ms. Bowman, my questions are for you. In your discussion with Mr. Tratham, you mentioned that one way DEC helps industrial customers with rate increases is the equal percentage fuel factor, correct?
For fuel rate
Yeah, for fuel
increases,
rate.
correct.
And isn't it true that when the company uses the equal percentage fuel factor to mitigate industrial customer rates, that the mitigation is recovered through the increase in rates of other customers?
It is spread throughout all customer classes.
Yeah, all right, thank you.
Thank you. Redirect?
Yes, just very briefly. Ms. Bowman, you were asked some questions regarding potential impact of this case and electric rates generally on industrial customers. You remember those questions?
Yes.
And you mentioned the fact that the company routinely engages with industrial customers to understand their business needs and the ways in which our service impacts them, correct?
That is correct. We have an entire team, large account management, dedicated to working with our large industrial customers.
And in your current role, is it not the case that you also personally meet with many of those customers on a fairly routine basis?
That is correct.
And as you've engaged with those industrial customers, have you heard from them as well that those customers value reliability and resilience of their power service to them?
Absolutely.
And is it your belief that investments in this case will in fact improve the reliability and resilience of the grid?
Yes.
In your engagement with industrial and other customers, have you also heard that many of those customers value cleaner energy as well?
Yes, many have sustainability goals.
And do you believe that the investments in this case will facilitate further clean energy on the system?
Yes, I do.
And as you think about the competitiveness of the company's rates, would you agree that one of the pieces of evidence around the competitiveness of the company's rates is whether other companies are looking to relocate to this state?
Yes.
And what can you tell this commission about the extent to which other companies are looking to relocate to this state?
We're seeing a tremendous amount of companies wanting to come to North Carolina. And as I mentioned earlier, North Carolina is rated again for the second year in a row as the top country in the U.S. to do business. We are seeing tremendous. I just look at some of the recent ones. Look at Wolfspeed, VinFast, the Toyota battery manufacturing plant, and there's a whole long list behind them. So North Carolina is definitely a place for economic growth.
Thank you. I have no further questions.
Okay, commission questions. Commissioner Klopfelter.
Ms. Bowman, we've got a lot of motions to excuse witnesses flying around here that are still pending. And you've provided the roadmap to what Duke witnesses are going to testify what subjects. So I want to be sure as we consider these motions to excuse that I know who it is that I might want to ask a question about on a particular topic. So if I've got questions going to the issue of the retirement dates that are being used for depreciation purposes in the rate case here, and the retirement dates that are being proposed by Duke and the newly filed IRP in South Carolina, do I direct those questions to Mr. Walsh, to Mr. Spanos, to both of them, or to some other person altogether? I just want to know who's my witness on questions going to that topic as we consider the motions to excuse.
Let me take a quick look.
Mr. Walsh is your fossil gas hydro fossil witness. Mr. Spanos is your depreciation witness. But if you tell me there's somebody else that I might direct those questions to, then I'd take that into account.
I would say either or.
Either or.
Either or.
Okay. Thank you. That's all I had. I just want to be sure I know who I'm letting go when we decide the motions to excuse. Thank you.
Okay, questions on commission questions? Okay, so you may step down. Neither of you are excused at this point. Thank you for your testimony. Mr. Dirac, you may call your next witness.
Commissioner Duffley, the company would call Dr. Roger Morin.
Okay, left hand on the Bible, raise your right. Do you solemnly swear that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Dr. Morin, would you please state your name, title, and place of business for the record?
Name is Roger Morin, M-O-R-I-N. My title is Emeritus Professor of Finance at the Robinson College of Business, Georgia State University, Atlanta, Georgia. And I'm also Distinguished Professor of Finance for Regulated Industry at the Center for the Regulated Industry, which I chair and direct.
And Dr. Morin, on January 19th, 2023, did you cause to be pre-filed direct testimony consisting of 79 pages, appendices A and B, and 9 exhibits to that testimony?
I did.
Were the appendices and exhibits prepared under your supervision and direction?
They were.
And are they true and correct to the best of your knowledge?
Yes, they are.
Do you have any corrections to your pre-filed direct testimony, including the appendices or the exhibits?
No corrections.
And Dr. Morin, if I asked you the same questions that are set forth in your pre-filed direct testimony today, would your answers be the same?
They would be.
And Dr. Morin, on August 4th, 2023, did you cause to be pre-filed rebuttal testimony consisting of 80 pages and 8 exhibits to that testimony?
I did.
Were these rebuttal testimony exhibits prepared under your supervision and direction?
Yes, they were.
Are the rebuttal exhibits true and correct to the best of your knowledge?
They are.
Do you have any corrections to your pre-filed rebuttal testimony or
No.
exhibits?
No corrections.
And Dr. Morin, if I asked you the same questions that are set forth in your pre-filed rebuttal testimony today, would your answers be the same?
Yes, they would.
Commissioner Duffley, sorry. At this time, DEC would ask that Dr. Morin's pre-filed direct testimony, including Appendix A and Appendix B, and pre-filed rebuttal testimony be entered into the record as if given orally from the stand, and that the Morin direct exhibits 1 through 9 and Morin rebuttal exhibits 2 through 9 be marked as pre-filed.
Okay, the direct testimony of Mr. Morin filed on January 19th, 2023, consisting of 79 pages, and Appendix A and B will be copied into the record as if given orally from the stand. The rebuttal testimony of Mr. Morin filed on August 4th, 2023, consisting of 80 pages, will be copied into the record as if given orally from the stand. The exhibits for the direct testimony, the 9 exhibits will be marked for identification as when pre-filed. And the 8 exhibits, which I understand are updated, exhibits 2 through 9 of the direct testimony will be marked for identification as when pre-filed.
Thank you, Commissioner Duffley. Dr. Morin, did you also prepare a summary of your pre-filed direct and rebuttal testimony, which has been filed in this docket in accordance with the directions of the commission?
Yes, I did.
Commissioner Duffley, at this time, I would ask that Dr. Morin's summary of pre-filed direct and rebuttal testimony be entered into the record as if given orally from the stand.
Dr. Morin's summaries of his testimony will be copied into the record as if given orally from the stand.
And Commissioner Duffley, with that, Dr. Morin is now available for cross-examination and questions from the commission.
Okay, SIG for 3.
SIG for 3 yields its time, but would reserve the right to cross-examine Dr. Morin if the company is allowed to recall him on rebuttal. Thank you.
Thank you. Commercial Group.
Thank you. Hello, Dr. Morin. Good to see you again, as always. Alan Jenkins for the Commercial Group. First thing we're going to do is test your contortionist skills.
All right. Good to see you too, I think.
Although these are the important people, so you're welcome to ignore me. I direct you to rebuttal testimony, page 77.
I'm there.
At line 4, you're rebutting Mr. Chris's ROE testimony by stating the commission should exercise a mind of its own when authorizing ROEs rather than simply following what other commissions do, correct?
I agree with that statement.
Now, for your convenience and that of the commissioners, we've prepared across CG, a potential cross exhibit 1. It's in these 2 books over on the right, the thin white ones.
Which number?
Number 1. And if you could please turn to page 13 of his direct testimony.
Mr. Jenkins, can we mark this?
Yes. We could mark that as Commercial Group cross-examination, Morin rebuttal exhibit number 1.
Okay, the document, and is this the document, our iPads are down, so I'm having to rely on my paper. Is this the direct testimony of Steve Chris?
Yes. So if
Okay.
you don't want to duplicate, it'll go in the record.
Okay,
Separately.
we'll mark it
Okay.
as Commercial Group cross-examination, Morin number 1.
Morin rebuttal, I think.
Morin rebuttal.
All right.
I think what we did the last time is do party. So Commercial Group, DEP, no, excuse me, Commercial Group, Morin, direct and rebuttal, cross-examination exhibit 1.
And you are the exhibit police, right?
After a momentary lapse
Yeah,
that went on
lapse.
for days in the DEP proceeding, yes.
So let me classify this document. It is Commercial Group Morin direct and rebuttal cross exhibit number 1.
Mr. Mehta, I think you had one more thing in there. Didn't you have DEC in there somewhere?
No, because this is the DEC proceeding.
Okay. Good enough. Page 13.
I have it.
Now, I direct you to this first answer on the page. Generally, you agree, don't you, with Mr. Chris's point here that this commission should exercise its own judgment in setting ROE and use average authorized ROEs only as a general gauge of reasonableness for the various cost of equity analysis in this proceeding?
I do, as long as this judgment is informed judgment.
Okay. In fact, you yourself use authorized ROEs as a general gauge of reasonableness of other ROE experts.
That's one of many benchmarks that I rely upon, yes.
Let's look at an example at your rebuttal, page 12.
My rebuttal.
And line 11, could you please read aloud the sentence there beginning Mr. Walters?
I quote, Mr. Walters recommended 9.55% ROE for DEC lies outside the zone of currently authorized ROEs for vertically integrated electric utilities in the United States, which average 9.73% so far in 2023.
Now, could you define
And
what is
I'm
your...
not finished.
Oh, I'm sorry.
I got to finish the sentence here. And have trended higher in more recent decisions, given the surge in interest rates and inflation.
Can you define what is your zone of authorized ROEs there?
Could you be more specific?
Well, you say there that Mr. Walters' 9.55% ROE lies outside the zone of currently authorized ROEs. And I'm asking, what is that zone?
9.73% is the average. And of course, it's an average, so some are below, some are above. But there's definitely an upward trend towards even crossing the 10% threshold. There are several recent decisions in the 10% or above range.
Now, it's true, though, that there are some authorized recent ROEs that are below Mr. Walters' 9.55%, correct?
Yeah, yes, they would probably be returns from past time periods when interest rates were lower, inflation was lower. I don't know what specific companies you have in mind or what time frame you have in mind, but definitely.
Excellent question.
Okay.
Let's look at
I'm concerned with now.
yes, let's look at the potential exhibit number 2 in your book, which we will ask to be marked Commercial Group Morin Cross-Examination Direct and Rebuttal Exhibit number 2.
And this is a document that's final order, findings of fact, conclusions, and order from the Minnesota Public Utilities Commission, correct? That document will be marked as Commercial Group Morin Direct and Rebuttal Exhibit number 2, and it was potential exhibit number 2.
And Dr. Morin, could you go to page 1 of that order? And under the heading Initial Filings, do you see that this was a multi-year rate plan proceeding?
Yes.
And I wonder if you could then flip to page 92 of the same order.
Yes.
And the last sentence before the paragraph starting 4 adjustments, it says there, does it not, the commission will set the company's return on equity at 9.25%, including flotation costs, correct?
Correct.
Now, XL is a company in your proxy group, right?
Yes.
And it also has nuclear, XL Minnesota has nuclear and coal generation at risk from Minnesota's aggressive move toward renewables, right?
That's correct.
Now, if you had included that in your zone of reasonableness, would not Mr. Walters' ROE have fallen within that zone of reasonableness?
Like I said, currently,
And this is a July 2023 decision, so that would be current.
That's correct, but we're in August 2023, and the average return right now is 9.73 and progressively inching higher and higher, unfortunately.
Now, that's a good point. Which then is closer, which ROE is closer to the 9.73% you mentioned? Your 10.4% recommendation or Mr. Walters' 9.55%?
As a pure arithmetical conclusion, it's obviously the lower one. That's arithmetic, not economics.
Even old guys like us can remember that, right?
Right. Speak for yourself.
That's right.
Just joking, of course.
Now, next, if you could look at page 43 of your rebuttal.
Okay.
And I direct you to line 9. You're talking there about your first general reaction to Ms. LeConte's ROE testimony is that Ms. LeConte's recommended 9.4% ROE for DEC lies outside the zone of currently authorized ROEs for vertically integrated electric utilities in the United States, which averaged 9.73% in 2023, right?
Yes,
So that's a similar point that you're making with respect to Mr. Walters, right?
exactly the same point.
And once again, which recommended ROE is closer to 9.73%? The 9.4% ROE you state is Ms. LeConte's recommended ROE or your 10.4%?
Well, as a matter of elementary arithmetic, hers.
Thank you. I wish we could talk hockey for longer, but that's all my question.
Thank you, Mr. Tynan.
Matthew Tynan for CUCA. Good afternoon, Dr. Morin.
Good afternoon, sir.
Dr. Morin, is it fair to say that the direct and rebuttal testimony you submitted in this case reflects your best efforts?
Absolutely.
And does the testimony represent the application of whatever expertise and knowledge you may have to the best of your ability?
Yes, it does.
And would you say that the answers you just gave apply to the entirety of the testimony that you've offered in this case?
Yes.
And so is there any part of your testimony that you offered that was just sort of throwaway testimony?
I don't throw away anything.
Was any of it off the cuff?
No.
Um,
Everything is seriously pondered and thought upon and supported by academic evidence.
Was there any of your pre-filed testimony to which you applied a lower standard of care in preparing it?
Could you explain what you mean by that?
Were you less careful preparing any parts of your testimony than you were other parts?
No, I'm always very careful about every line.
You apply the same level of care throughout all of your testimony?
Yeah, very consistent.
And so you would say that your pre-filed testimony represents a constant level of rigor and application of expertise. Is that right?
Well, I hope so. I hope the commission considers
And
the
you
same way.
You reviewed your pre-filed testimony in preparation for today, did you not?
Yes.
And is there any portion of your testimony that you would like to disavow as not being the product of your best efforts?
No.
Let's start with flotation costs. You recommended in your testimony the commission gross up the allowed ROE by 20 basis points to account for flotation costs. Is that right?
That is correct.
And you made the same recommendation in the DEP case, right?
That is correct.
And just as an aside, would you agree that your pre-filed direct testimony in the DEP case is substantially identical to the pre-filed testimony in this case
Yes, it is.
with slight adjustments to the
Yes.
numbers?
If it were not, you'd be the first one to point out discrepancies.
And did you read the commission's order in the DEP case with respect to flotation costs?
Yes.
The commission disallowed flotation costs, right?
Yes, it did.
And notwithstanding whether you agree with the economics of the disallowance, would you agree the commission correctly stated North Carolina law to preclude an allowance of flotation costs when there's no evidence of any intent to issue new equity?
Well, I disagree with that because the whole idea of flotation costs is not only to recover the ones that are anticipated in the test year, but also the ones related to past issues of common stock. And the analogy that I always give you is even though the company is not building new generating plants, it still continues to recover past generation investments through depreciation charges over time, even though they're not building new plants. It's exactly the same idea for flotation costs. You got to recover the costs associated with past flotation costs on a sort of perpetuity basis.
So as a matter of economics, you think that flotation costs are appropriate, right?
Absolutely. Equity is not free.
But as a matter of North Carolina law, you understand that flotation costs are not allowed unless there's some evidence that there's an intent to issue new equity. You understand that?
Yeah, I understand that, but equity is not free. We do it for bonds. Why not for stocks? Yeah.
Are you aware of any change in circumstance that would alter the commission's conclusion that Duke Energy does not intend to issue new equity before 2027?
What I just said a minute ago. Flotation costs associated with past common stock issues have to be recovered in the same way that past investments in generating plants continue to be recovered through depreciation charges.
I understand, but are you aware of any evidence that Duke Energy intends to issue new equity in the future?
Well, they're going to have to with a $7 billion CapEx, capital expenditure program in the next 5 years. Half of that will come from equity and half from debt. I'm not sure there'll be enough retained earnings to meet the equity component, and they may very well have to issue stock.
Are you aware that Duke Energy has publicly stated it does not intend to issue new equity before 2027?
Yeah, I think it'll be sooner than that, but that's my opinion.
That's speculation from you.
Informed speculation.
So given what North Carolina law is, would you concede that your recommendations for ROE should be reduced by 20 basis points, notwithstanding your objection to the economics of flotation costs?
Well, it's the commission's prerogative to do that, yes.
And they would be correct to do that under North Carolina law, right?
I would not agree with it, but under law, they would be.
Are you aware of any North Carolina law that's different from what the commission cited?
No.
Dr. Morin, your testimony includes a lot of references to how investors perceive investments in utilities. Is that fair to say?
Yes.
And are you familiar with the concept of portfolio investing?
Of course.
Isn't that the approach taken by large institutional investors?
Yes, institutional investors, mutual funds, pension funds take a portfolio approach, a blending of debt securities and equity securities, and of course, short-term securities.
So they're able to offset the risks of particular companies by investing in a group of companies, in other words.
Well, the portfolio as a whole is less risky than any of its parts, to the extent that you're blending debt and equity together.
Is it fair to say that your proxy group includes some utilities with lower average earnings and some with higher average earnings than Duke Energy?
Probably, yes, but that did not enter into my construction of the peer group.
And to your knowledge, are each of the utilities in your proxy group able to obtain capital?
Yes, probably at different costs, but I would say yes.
Why don't the investors only invest in the companies with the best risk-adjusted returns?
Well, why wouldn't you? If you find a risk-adjusted return of 10% and every alternative is 8%, you're going to buy the 10% one.
But all of the companies in your proxy group, despite their differences, have investors, isn't that right?
Yeah, they're all equivalent in risk. That's the whole nature of a proxy group.
Speaking of your proxy group, isn't it right that you use the average beta of the proxy group to calculate the allowed return on equity for DEC in your CAPM and ECAPM models?
That is correct.
And that's the same as in your DEP testimony, is that right?
That's correct.
If you were to replace a company in the proxy group that had a low beta with a company that had a higher beta, that would increase your average beta, right?
If I were to insert a lower beta?
If you were to replace a company that had a lower beta
yes,
with a company that had a higher beta, you would increase the proxy group's average beta, is that right?
Yeah, the average would increase slightly.
And that would have the effect of increasing your calculated CAP-M and ECAP-M rates of return, right?
Yes, it would, in the same way that if you included a lower beta, it would lower those estimates.
Your DEP and DEC proxy groups are almost the same, isn't that right?
I think so, except for one company that is no longer covered by value line.
Right, so you removed MGE Energy and inserted DTE Energy in this case, is that right?
That's correct.
And you did that because MGE Energy is no longer covered by value line?
That's correct.
On page 6 of your direct testimony, you mentioned that increases in utility yields and interest rates from September 2022 to January 2023 led you to increase your ROE recommendation from 10.2 to 10.4. Is that right?
What page are you?
Page 6 of your direct testimony.
Okay. What line number? Oh, I'm sorry.
It's the very last line.
Yeah,
on
I
page
got
6.
it, yes.
And
Yes,
I noticed that in your rebuttal testimony filed in April 2023, in the DEP case, you didn't include any adjustment for this apparent increase in yields and interest rates, isn't that right?
That's correct.
And is that because your conclusion in that case that 10.2 was a fair rate of return for DEP was already satisfied, so you didn't need to change your testimony?
At that time, but I have updated the recommendation using much more current data, and it's still 10.4.
But you didn't change your recommendation in the DEP case, right?
No, I did not.
Besides the change in interest rates and yields that occurred over the 3 months from between when DEP filed its case and DEC filed its case, are you aware of any other reason that DEC's allowed rate of return should be different from what the commission allowed for DEP?
Yes, it should be 10.4 as I recommended.
Are you aware of any substantive difference between the companies that would justify the two companies having a different rate of return?
No, I would not be aware of any difference that would warrant a difference in allowed ROE. The only thing I would alert the commission to is that shockingly and surprisingly, in the last week or so, the risk-free rate, meaning the U.S. Treasury bond yields, have increased by a huge amount from the 3.9% to 4.3%. That's a huge increase in long-term interest rates. It's very unfortunate. I did not factor that in my updated recommendation, but the commission should be aware that unfortunately, interest rates are still going up.
And is it your opinion that the legally authorized rate of return that will apply for multiple years in a multi-year rate plan should depend on something as fickle as changes in interest rates over months or weeks?
No, not over months or weeks. That's why I'm not changing my recommendation. It would take quite a black swan event to change the recommendation substantially.
Aren't rates just as likely to go up as they are to go down over the period of a multi-year rate plan?
They are, but all the forecasts that I'm aware of is for a continuing increase in interest rates because of the Federal Reserve Bank's obstinate policy to get inflation down to 2%.
And have you made any of your own personal investing decisions based on your understanding that interest rates are going to go up?
No, I let the experts handle my.
You're not willing to put your own money on that bet?
No, not really. I'm a buy and hold kind of guy.
You would
Long
put
term.
that, you would make North Carolina ratepayers place that bet though, wouldn't you?
What do you mean by that?
You're asking the commission to authorize a rate of return based on increasing interest rates, and you're trying to stick North Carolina ratepayers with that increase, but you yourself aren't willing to bet your own money on those increases?
Well, you know, I'm a buy and hold type of investors. I hold diversified portfolios, and there's a lot of debt securities because I'm a pretty old guy. And interest rates go up, bond prices go down, so I suffer too.
You note on page 50 of your testimony that a CAPM-based estimate of cost of capital underestimates the return required from low beta securities and overstates the return required from high beta securities based on empirical evidence. And that's at lines
Mr. Tynan, is that page 50 of the rebuttal or the direct?
direct, and that's at line 6 through 8.
I have it.
that. Is that correct?
Correct. Yes, it is. You can see on the graph.
And so you talk about using what you call ECAPM, which you consider to be an empirical approximation to CAPM. Is that right?
That's correct.
And the idea with ECAPM is to model the difference observed between the returns on low beta stocks and what the CAPM model would predict.
That is correct, and that is vividly demonstrated by the graph on page 50. The darker line is the CAPM, the textbook CAPM. The one that's more steeply sloped is reality. This is what we observe between return and risk. This is the real world. And you can see that for companies with betas less than 1, like utilities, although they're getting awfully close to 1, the CAPM slightly understates. You can see the difference in the two lines there. And conversely, for the high-risk securities, it overstates the return.
And so the ECAPM model results in the equation at line 13 on page 50 of your direct testimony.
Page 51.
Line 13 on page 50, there's one equation.
That's correct. But
And then on line 8 on page 51, you have what you call an equivalent equation. Is that right?
that's correct. That's the
In the regular CAPM model, a beta of 0 will return the risk-free rate. You plug it into the formula. Is that right?
yes.
And looking at quickly at the equation on page 50 at line 13, if you plug in a beta of 0, you get a return of the risk-free rate plus alpha. Is that right?
That's correct.
And so the ECAPM model predicts that the risk-free rate is the risk-free rate plus alpha, right?
At the very, very low end of the risk spectrum, yes.
And then if you look at the equation on page 51, line 8, if you plug in a beta of 0 there, it predicts that the risk-free rate is 0.75 times the risk-free rate plus 0.25 times the market premium rate. Is that right?
The reverse. 0.25 times the MRP plus 0.75 times beta times the MRP.
And thank you for that. And so basically that second equation predicts that the risk-free rate depends somehow on the market premium rate. Is that right?
The risk-free rate is the risk-free rate. It's the yield on long-term treasury bonds, U.S. treasury bonds.
So at a beta of 0, in other words, the ECAPM model doesn't correctly reflect reality. Is that fair to say?
Only at the very, very, very low end of the market.
When does it start reflecting reality?
Probably around 0.1 or so, beta of 0.1.
Have you done a study to figure that out?
No, I've never seen any security with a beta that low.
You're just speculating.
No, it's informed judgment. I've never seen a beta as low as 0.1.
So you don't really know. Is that fair?
Well,
to
I
say?
do. I've never seen a beta that's 0.1.
So you haven't seen any data that gives you the knowledge about when ECAPM starts working in terms of beta.
Again, I answered the question. I've never seen a company with as low a beta as 0.1.
And just to clarify, we talked about the first equation comes up with, if you plug in a beta of 0, you get RF plus alpha. If you plug in a beta of 0 into the second equation, you get 0.75 times the risk-free rate plus 0.25 times the market premium rate. And those are two completely different numbers. Is that fair to say?
That's correct.
And so isn't it true that those equations aren't really equivalent?
No, the equation on page 50 is the academic theoretical equation. The one on page 51 is my approximation to that to make it easier and more tractable and easier to follow. Instead of imagine asking somebody to do a statistical analysis relating returns to beta for thousands and thousands of stocks. It would be laborious and impractical. In my formula on page 51, all you have to do is insert the beta, the risk-free rate, and the MRP. You've got it, boom, like this. So I'm doing a very good service to users of these models.
On page 66 of your direct testimony, you cite declining demand growth as one issue facing utilities. Is that right?
Well, demand growth per customer,
And-
usage per customer.
And does decoupling of residential rates mitigate that factor?
A little bit, yes.
And then also on page 66 at lines 11 to 12, you state that electric utilities are beset by lower allowed returns. Do you see that?
Well, they were for the last 10 years with declining interest rates. Obviously, the allowed returns followed suit. And now we're at the reverse situation where rising interest rates imply rising ROEs.
So would you say that now electric utility companies aren't really beset by lower allowed rates?
But they were for a long time, and now they're going to have higher rates of returns because of higher costs and higher risks.
At page 4 of your rebuttal testimony, you state that your proxy group, quote, takes into account similar risk mitigating mechanisms that are pervasive in the industry.
Yes.
Is that correct?
That's correct.
And did you examine each and every subsidiary utility of the companies in your proxy group to see what risk mitigating mechanisms they had available?
I looked at it. If you look at each company in the proxy group, there's 23 of them. About 15 of them add capital cost trackers. 9 of them add distribution trackers. And the ones that didn't had other risk mitigating mechanisms such as forward test years, such as MYRP, and such as forward test years. So all of these companies basically have a suite, an arsenal of risk mitigators to try to combat regulatory lag.
Do all of the companies have those risk mitigators? Or just many of them?
I would say the vast majority. I didn't see any one of them not having any at all, except maybe 1 or 2.
And
the vast majority is, hey, listen, this is mainstream stuff. I mean, they
but
all have it.
The companies in your proxy group have different kinds of risk mitigators. Is that fair to say?
That's fair to say.
Do they have the same exact kind of risk mitigators that are available to DEC in North Carolina?
Not to the micro details, no.
Did you,
For example, no. For example, one might have a different sharing mechanism of earnings than the other one, but as far as investors are concerned, they look for the presence or absence of risk mitigators.
So investors don't really care what mechanisms there are. They just
Well,
know there are mechanisms.
They care, but as long as the commission is supportive to offset all these new risks that have appeared with the decarbonization of society, basically, to try to offset these risks by these mitigators.
What does the commission being supportive mean?
Meaning allowing approving those risk mitigators.
So if the commission approves the use of those risk mitigators, that's seen as supportive.
That's correct. I think the reverse proposition is more telling. If the company did not have any of the risk mitigators, they would deem to be riskier than the average, the peer group. Imagine the company not having a fuel adjustment clause, like everybody else has one. So that company, in the absence of such a clause, would be deemed riskier. It's the same thing for risk mitigators.
On page 5, lines 4 to 7 of your rebuttal testimony, you state that from the viewpoint of investors, risks that are diversifiable simply do not show up in cost of capital estimates. Is that right?
That's according to modern portfolio theory. If you can diversify away these risks, it's not relevant.
Is that a way of saying that investors don't really care about the details of individual companies?
Well, they can diversify away a lot of those details by having a portfolio of my 23 peer companies, for
So
example.
for instance, an investor in DEC could diversify away any problems they see with investing in DEC by investing in other utility companies. Is that right?
They could, yes.
Um, on page 9, at line 13, and continue on to page 10, line 2 of your rebuttal testimony, you cite the fact that interest rates have gone up since the commission awarded DEC an ROE of 9.6 in the prior rate case. Is that right?
Yes.
And then page 10, line 3, you state that intervener witnesses proposals of ROEs that are below 9.6, quote, defy reason and logic. Is that right?
Yes.
And am I correct that none of the methodologies you employed in your testimony start with the previously authorized rate of return?
No, they don't.
And so you understand that the commission ended up authorizing a rate of return that was in between what intervener witnesses supported in the last rate case and what DEP's witnesses proposed in the last rate case, right?
That's correct.
And do you understand that the rates that were suggested in the testimony of public staff witness Walters and CUCA witness LeConte are in fact higher than the rates of return suggested in the testimony submitted by those parties in the last rate case?
They are higher?
They are higher.
Yeah, well, they should be. Interest rates are higher and the risks are higher.
Does that conform to the logic that you would expect?
Yeah, the higher the level of interest rates, the higher the risk, the higher the return.
The fact that their recommendations in this case are lower than the previously authorized rate of return is really not important.
Well, it's important. It doesn't make any sense.
They don't start with that rate, right? They calculate it from first principles. So why should they expect to hit some number above 9.6?
Well, they didn't proceed correctly with the wrong inputs in the models. That's all I can tell you. If interest rates go up and risks go up, returns go up. Unfortunately, that's reality.
Page 45, lines 3 to 4 of your rebuttal testimony, you criticize witness LeConte's proxy group for excluding Eversource and First Energy because you concluded that those two utilities are, quote, are indeed vertically integrated electric utilities. Do you see that?
Yes, they are.
And you base that conclusion on the fact that you examined those companies' 10K reports and, quote, found the word generation appearing many times. Is that right?
Well, a little bit more than that. If you go ahead and Google First Energy, the first thing you're going to find is they are a diversified, vertically integrated distribution, transmission, generation utility. They have at least 4,000 megawatts of generation capacity. So I didn't have to go much further than that. They are a vertically integrated utility. Now, with respect to the other company, which is, I think, Eversource, excuse me. She does have a point. They have the company has basically sold most of its generation capacity, but they still have one. It's called Dominion, Northeast Dominion, which is a generator of power.
So in your testimony, when you say you examine the 10K reports,
yeah,
what you mean is that you hit Control F and typed in the word generation and counted how many times it popped up. Is that right?
No, I did a little bit more than that. I read what the context of the sentence where the word appeared. There's no question that First Energy is one of the biggest utilities in the country, and they have generation capabilities.
But as to Eversource, you would now say it's not.
She has a point there. It's very small.
And your Control F search of Eversource's 10K didn't reveal that to you?
No, I found it in some other source. No pun intended here.
So in your testimony.
Also, I deleted those two. Instead of 9.8, it was 9.01 or something. It had a very minuscule impact.
So in your testimony, when you say you examined the Eversource 10K, what you mean is you did a Control F search and that was good enough for you and you moved on?
Yes, but reading the context of the sentence in which the word appeared.
And did you read the context? Do you know how many electric subsidiaries Eversource has?
No, I do not.
We can look at the 10K if you want, but would you take subject to check? There's only 3.
Yeah, I would accept that, but they do have one.
And those are CLNP, NSTAR, and PSNH, right?
Right, but they do have Northeast Dominion generating subsidiary.
And none of those entities own any generation, isn't that right?
I just said they have a subsidiary called Northeast Dominion that has have generation.
Mr. Tyne, it's time for an afternoon break. We need to let the court reporter rest her hands. Let's take a 10-minute break and we'll be back at 3:55. Back on the record, before we begin questioning, I just wanted to say our thoughts are with UNC today. I have heard that the suspect is in custody. So with that, Mr. Tynan, you can begin.
Dr. Morin, before we broke, you were talking about your understanding that Eversource Energy has a subsidiary named Dominion Northeast. Is that right?
I think it's called Northeast Generation.
And is it your understanding that that's a vertically integrated, regulated utility?
No, it's a subsidiary of Eversource, which is almost a vertically integrated electric utility. But less and less so.
I've put in front of you, open for you to tab 18 of CUCA's potential cross-examination exhibits. So this is CUCA potential cross-exhibit 18. And Commissioner Duffy, I'd like to mark that as CUCA Morin direct and rebuttal cross-examination exhibit 1.
Which potential exhibit is it?
It's potential exhibit 18.
18. Okay, thank you.
And
So this will be marked KUKA Morin direct rebuttal exhibit, cross exhibit 1.
yes, thank you.
Thank you.
And if you turn, and Dr. Morin, I've already done this for you to prevent some time wasting here, but for those following along electronically, I'm looking at PDF page 7, which is the front face of the Eversource Energy Form 10K for the year ending December 31st, 2022. Do you recognize that?
I haven't.
And is that the 10K that you examined in the course of preparing your rebuttal testimony?
I don't remember.
Would you have dug for a past 10K for some reason?
Again, I don't remember which one I looked at. This is December 31st. I may have looked at the quarterly one. I don't remember.
If you turn to the page that has the Arabic numeral 2 at the bottom, so you got to turn a few more pages.
Yes.
I
have it.
You recognize under part 1, there's item 1 business. You see that? No, the Arabic numeral 2, the top of the page starts energy source, energy and subsidiaries. The header at the top.
Okay.
And that would be PDF page 14 for those following along electronically.
I can't find it. I just have to point it out to me.
Could I approach the witness?
Yes, you may.
Oh, that's not. Yep. So it was number 2, not Roman numeral 2. Okay.
And do you see under item 1 business that there is a list of subsidiary companies of Eversource Energy?
Yes.
And among those are Connecticut Light and Power, or CLNP.
Yes,
right?
I do. Yeah.
And NSTAR Electric Company, right?
Yeah, I see it.
And there's also Public Service Company of New Hampshire, PSNH, right?
Yes.
And then there's also NSTAR Gas, Eversource Gas, Yankee Gas, and Aquarion Company. You see those?
Yep.
And NSTAR Gas, Eversource Gas, Yankee Gas, and Aquarion, those aren't electric utilities, are they?
They're not, no.
And if you go down near the bottom of the page that you're on, page 2, right above the word rates, the last line of the paragraph above the word rates says CLNP does not own any electric generation facilities. Do you see that?
Yeah, that's one of the subsidiaries.
And when you examine the 10K that said CLNP does not own any electric generation facilities, what made you conclude that this was a vertically integrated utility?
Because it does have a subsidiary called Northeast Generation. And if you actually remove it from the DCF analysis of the peer group on exhibit REM 2 and 3, the difference is 0.01. But I would grant you that Ms. LeConte has a point. It's not a very big, large, significant vertically integrated utility. I will definitely grant you that.
But you concluded that it shouldn't be excluded because you found the word generation a bunch of times. Isn't that right?
Yes, I did, but I found it in the context of Northeast Generation subsidiary.
So you don't remember what 10K you looked at, but you specifically remember one company.
Yeah, I do. Well, I was looking for generation.
And would it surprise you to learn that the second reference in this 10K is a statement that CLMP does not have generation assets?
CLP is one of the many subsidiaries of the company.
And the very next result for the word generation is a statement that NSTAR does not have any electric generation facilities.
Yes, correct.
And the next statement involving the word generation is one that says PSNH does not have any electric generation facilities.
Listen, I just told you they have Northeast Generation. That is a generation subsidiary, period. And you can remove it if you want. It makes no difference in the result.
Did you know that the term Northeast Generation does not appear anywhere in the 10K report for this company?
Well, I'll have to show you where I got it from.
Did you just make it up?
Yeah, sure. Of course I didn't.
At page 50 of your rebuttal testimony, lines 8 through 10, you suggest that witness LeConte should have gotten a different result for her CAPM calculation. Do you see that?
Yes.
And I take it your point there is the commission should put weight on what LeConte should have gotten, which you calculated to be 10.3%. Is that right?
Yes, it's merely a correction in input data.
Because with the corrections that you proposed, her methods would be right and her CAPM estimate would be acceptable to you. Is that right?
It would be one estimate. That would be correct, yes.
And would it be reasonable for the commission to authorize an ROE, say, 20 basis points lower than witness LeConte's CAPM estimate as corrected by you?
No.
In your correction of witness LeConte, you state that a risk-free rate of 4.3 combined with a beta of 0.85 and a market risk premium of 6.5 should have yielded a CAPM estimate of 10.3. Do you see that?
Yes.
And that's just from plugging the risk-free rate, beta, and MRP into the CAPM equation that you have in your testimony at page 35, line 1.
Correct.
Do you have a calculator handy?
No.
Would you agree that the arithmetic you did on this page is incorrect?
Show me.
4.3 plus 0.85 times 6.5 is 9.825.
Okay.
You take that subject to check?
Yes, I will.
So as corrected by you, the correct CAPM estimate that LeConte should have come up with was 9.8. Is that right?
$9.8?
Correct.
Yeah, sure.
You just flubbed the arithmetic there in your testimony.
I'll have to check.
And that represents your best level, your best efforts and level of rigor that you applied to the rest of your testimony. Isn't that right?
No, not really.
So there's some parts of your testimony that are just sort of garbage and other parts that you want the commission to rely on.
I resent that comment very much.
No further questions.
Mr. Neal.
Commissioner Duffley, it's David Neal for NCJC et al. I at risk of trying your patience, the pending motion would streamline our cross to the point where I wouldn't have any questions. So I don't know if there's any update from the commission on our pending motion.
I was going to review all of the documents one more time tonight. However, the commission, in consultation with others within the commission, we're leaning towards not allowing the motions.
And as a follow-up question, if the witness agrees that the answers that he gave on cross in the DP hearing are the same, would the commission accept it as a cross exhibit? So not as part of the testimony, but as a separate cross exhibit?
Correct. If you wanted to create a cross exhibit to place into the record as a cross exhibit, that might be more palatable, or the use of judicial notice.
And with that, Dr. Morin, good afternoon.
Good afternoon.
You recall being asked a series of questions by myself, other interveners and the public staff in the DEP rate case, correct?
Yes, I do.
And that was docket E2 sub 1300?
Yes.
And you appeared on May 4th and May 5th of this year, isn't that right?
Yes.
And if you were asked those questions today that you were asked on May 4th and May 5th of this year, would your answers be the same?
Yes, they would.
And with that, and I did, Commissioner Duffley, I did include as potential cross exhibits the entire transcript from when Dr. Morin appeared and the exhibits. But what I would offer is to take the portions of the transcript that Duke agreed to and create a cross exhibit tonight that covers those portions of the transcript instead of the entire transcript. I would then offer that as a cross exhibit at this time, but I have to do, based on the feedback we got from Duke last night, have to streamline what we have from the cross notebook.
Mr. Neal, let's do this because I'm going to want to look at that cross exhibit before agreeing to this type of construct. So why don't you do that tonight? And if you have no further questions, we'll move on to the public staff and we can come back to you depending on what you've prepared and how the commission rules.
Thank you. Thank you, Commissioner. We'll do that.
Commissioner, should I proceed or was?
Yes, please proceed. We're going to take things out of order.
Okay. Dr. Morin, good afternoon.
Hi.
It's good to see you again. Before I question you, I just want to take a slight legal matter and say, to the extent that Duke is attempting to reserve the ability to have you be examined on your direct and rebuttal and then be called back again for a second rebuttal, I'd object to that. But I think last time when the issue came up, Duke said it was unlikely and that we should argue it at a later time. But I just wanted my questions to be subject to that objection.
Sure.
Today we are here to help inform the commission about what a good return on equity is for Duke.
Yes.
Duke Energy Carolinas. And I think that we discussed before that if the return on equity is set too low, that results in an improper transfer of wealth from shareholders to ratepayers.
Correct.
And if conversely, the return on equity is too high, that results in an improper transfer of wealth from ratepayers to shareholders.
That's correct.
So we don't want either of those scenarios, do we?
No, we don't. We want the rate of return set equal to the cost of capital.
We're looking, and that's what this part of this exercise that we're doing here is to help us figure out that equilibrium point.
Correct.
And because we're a monopoly, we don't have competition, so we have to rely on regulation to supply that competition. It's a substitute for the marketplace.
Yeah, I see regulation as a proxy for competition, basically. What would the result prevail under perfect competition?
So we're trying to fathom what would happen. How we can ascertain under, if there were an efficient market with perfect competition, we're trying to fathom the return that Duke Carolinas would get.
That's correct, which is in turn based on the return expected by investors on comparable risk investments.
Okay. And that's not a simple mathematical exercise. You can't just say whatever the S&P for utilities is, that's what it is, right?
That's correct.
We've got to use informed judgment to come up with the appropriate return on equity.
I agree with that. We have models and we need to come up with the right inputs.
But it's also more than the models. The commission can consider what other commissions have done, because that would affect the cost of capital, can consider what the company has said, various matters, right? It's not just mathematical models.
No, it's not. There are other factors that could come into play, give and take on other items on the regulatory platter, so to speak.
Is that
you
why?
know, but the commission has a mind of its own, and that's great.
Do you think that's why ROE is one of the more heavily litigated areas?
Yes, it's complex. It's highly academic and appears to be very complicated. And yes, and it's contentious because the inputs to the various models require some judgment. So it is a more difficult and more fragile area, but it could be worse. It could be depreciation.
Yeah. So I guess as we sit here this very minute today, we have a 9.6 ROE from the last rate case. That's E-7 sub 1214.
Yes.
Okay. And that's that order was issued in 2021, so 2 years ago.
Yes.
And you're not the cap structure witness, I get that, but that was a 52% equity.
Yes, I do recall that.
So the burden here is on Duke to demonstrate to the commission why an 80 basis point increase is appropriate for these couple of, well, 2 years and a little bit since the order was issued, right?
That's correct.
Okay. I mean, it seems to me, I thought inflation was getting more under control. I thought the Federal Reserve indicated it might not go too much higher with interest rates.
I was very confident that that would happen myself. We saw a slowing down, so to speak, of inflation from the 7% area down to the 4%, even 3.8, 3.9. And I thought interest rates had stabilized. But shockingly, about a week or so ago, interest rates shot way up by 40 basis points. That's a lot. Probably because the U.S. government is going to issue more than $1 trillion of bonds on the market. And of course, that will exert upward pressure on interest rates. And I think the Federal Reserve is reluctant to abandon its 2% target on inflation. It will continue to be restrictive, and while trying to avoid what we call a hard landing.
It feels like some of your rate of returns have sort of ping pong back and forth between 10.2 and 10.4 lately.
Yes, they have.
I was kind of hoping it would bounce back to 10.2 again because of some of these, because the Fed is saying that they might not keep going up with interest rates. What would it be next year?
What would what be?
What do we guess is going to happen in the future?
I don't forecast interest rates, but I can tell you the consensus forecast is in the 3.9, 4.0, 4.1 area. It still is. But the current interest rate is actually higher than the forecast. So I would concur with that.
So if interest rates do come down, and would you expect ROE to come? And I think you called it sticky last time, but would you expect if interest rates were to go down, which is hypothetical, would we expect ROEs to go down?
Yes, we would. Conversely, of course.
Conversely, you would tell us that if interest rates go up, you would expect allowed returns on equity to go up as well.
As they have. There's a rule of thumb that I've learned over 40 years and more than 200 cases. Every time the interest rates go up 1%, the ROEs go up half of that. I call that the elasticity factor. So if interest rates go up 40 basis points, the ROE typically will go up 20 basis points, half of that. Of course, it works in reverse. If interest rates decrease by 40 basis points, ROE will typically decrease by 20 basis points. That's what we call the elasticity factor.
In 2021, the ROE was 9.6.
Yeah.
And now we're at 10.4. That's 80 basis points.
Yes.
So if we did your rule of thumb, that would be, you have to do twice that, right? You said it's up 50, for every percent up, you get 50. Is that what you said?
No, I said every time interest rates go 1%, typically the ROE will go up 0.5%.
Okay.
Conversely, of course.
So
that's assuming risk hasn't changed.
Okay, I understand what you're saying. We sort of have the benefit sitting here today of seeing the Duke Energy Progress Order, which is, we saw a 9.8 ROE in that case. And I didn't see that headlining on NBC News or anything, but I did see in some of the industry publications, it was referred to as constructed and expected. Is that sort of in line with your thoughts on it?
I was expecting a little bit more than that.
I know you were.
Yeah.
You were expecting 10.4, obviously. But would you say that the industry has treated that as constructive and expected?
I think the bond rating agencies will and have reacted favorably to the. My range is 9.8 to 10.8, so it's 1% range. So it's at the very bottom of my range.
I understand. When you were doing your rebuttal testimony, you took issue with certain assertions made by the public staff witness Walters.
Yes.
I also saw a new witness showed up, Mr. Coyne, I think it's pronounced.
Yes.
He also took issue with some of Mr. Walters.
I guess he did.
Tell me your understanding of the different roles that you and Mr. Coyne.
I have no idea.
Okay.
I thought my rebuttal was pretty thorough and complete and detailed and to the point, and I asked the company that, not me.
Okay. Did you and Mr. Coyne work together to come up with his testimony?
No, I don't know him, never met him.
DEC here has a beta that is slightly more favorable than the average utility beta.
Yes, beta of Duke Energy is 0.85, and the average right now is about 0.89, 0.9.
Okay. Does that mean that relative to its peers, Duke Energy Carolina is slightly less risky?
No, it doesn't mean that, because we have to be very, very careful when we estimate the beta for one company, because there's all kinds of measurement error. So a much more powerful and statistically meaningful measure of beta is when you use a portfolio of companies, like my peer group of 23.
Okay.
And most textbooks in finance warn you about the dangers of estimating a beta for just a sample of one.
Is beta a measure of volatility?
It's a measure of volatility relative to the market.
Yes. Okay. Which is also a sort of, we could also refer to that as risk as well.
Yes, according to financial theory, it is the most singularly important measure of risk in finance.
Okay.
It's embodied in the CAPM model, beta.
The betas that you use in the CAPM model for the proxy group, you said the whole proxy group is 0.89, 0.9 beta.
Correct.
And the same beta for Duke Carolinas is less than that.
Yes.
Okay. Just generally speaking, my impression of North Carolina's regulatory climate and commission is that it's excellent.
I agree with that. It's supportive.
Supportive.
Hmm.
If you would look, there's some notebooks over here. There's a tab 18 in the large one that says 1 through 40, I believe.
Number one,
Tab 18 in the big one.
they're all big. That Arizona?
Mr. Freeman, is this a potential exhibit?
Yes, it's the regulatory state evaluations for energy,
What's the potential cross number?
18. And I would like to mark it while Dr. Morin finds it, Commissioner, as
Why don't we mark it as Public Staff Morin Direct and Rebuttal Cross Exhibit 1?
I have it.
Thank you. If you'd look on page 4 of Exhibit 18, which has now been marked as Exhibit 1. And you can see here, North Carolina has a rating according to RRA of above average /3.
I agree with that, yeah.
You agree that RRA says that, and you also agree with other RRA's conclusion.
Yeah, I do. There's similar evaluations by other entities as well. Value Line and so forth. I agree with that.
Okay. And RRA is a source that you personally have relied on in data and analytics and evaluations.
I often refer to the average authorized returns on a quarterly basis using this publication.
It's a reliable publication.
Yes, it is. It's a subsidiary of S&P Global Intelligence. And I'm a faculty member there at S&P Global, so. Now that you show me this graph, a few days ago, I was in Arizona, which is black there. That was a very uncomfortable situation. The commission there was ranked at the very bottom.
And actually, if you would like to turn with me to what is now marked as Exhibit 1, but page 9 of 32. Exhibit 18.
I have it.
Page 9 of 32. There's only one state in the lowest category, below average, it's Arizona.
Yeah. And of course, when that awful decision came out, 2021, with the lowest rate of return in the country, immediately the bonds were downgraded. And they're still on negative outlook, even after the downgrade. And as a result of that, the CFO testified that the borrowing costs had increased by 60 basis points compared to the other utilities that were rated Baa1. That's huge impact on ratepayers. So that's a very good example of it's in everybody's interest to have a strong rated single layer Baa1 utility. It's in the interest of ratepayers and shareholders. And the commission being supportive, it goes hand in hand with being supportive of not only investors, but also trying to minimize revenue requirements. I spent a lot of time in my textbooks talking about the optimal bond rating for ratepayers, and it's definitely single A. A strong single A bond rating is good for everybody.
Strong single A bond rating is good for everyone. And then what is one notch below that Baa1?
That's correct.
Okay. You think strong single A?
You know why though? I mean, the difference in yields is 30 basis points. Okay. Every time the company borrows $100 million on a 20-year bond, that extra 30 basis points costs $6 million to ratepayers. For $1 billion of debt, it costs $60 million to ratepayers. If the company is going to raise roughly $3.5 billion of debt next 5 years, it's over $200 million extra burden on ratepayers. We don't want that. That's why I'm a strong advocate of a strong A-rated utility. It's good for investors. It's good for ratepayers.
Okay. let's talk about what a basis point is worth. And do you have my notebook still there?
Yep.
Okay. If you will turn with me to exhibit, pardon me, Doctor. 5.
I have it.
Mr. Freeman,
Oh, sorry.
do you want to mark the exhibit?
I've proposed to mark this, Commissioner, as Public Staff Cross-Examination Morin, Direct and Rebuttal, Exhibit 2.
Okay, and the title, I think and Mr. Mehta, you can correct me if I'm wrong, but I think that the style that we're using is Public Staff Morin Direct and Rebuttal Cross Exhibit number 2. And this is potential exhibit 5, which has at the top of the document, impact of 1 basis point.
Correct. Would you say one more time the naming convention?
Public Staff Morin Direct and Rebuttal Exhibit number 2.
Commissioner Duffley, you get it.
Cross exhibit.
A
number.
plus. Well, I was going to say cross exhibit would have given you an A plus.
Yes.
Commissioner Duffley?
Yes.
Before Mr. Freeman gets too far into this exhibit, it is composed of a cover page, then an answer to a data request, and appears that the last 3 pages are the answer to a data request. I have no problem with the answer to the data request being discussed and in evidence when we get to that point. In this case, the cover page has 0 foundation. And I would object to any examination on the cover page.
Mr. Freeman?
The cover page is multiplying out or adding the zeros in to the response to the data request. Was this 203? Yeah. This document, the document behind the cover page is, if you look on page 404, Commissioner, you can see rate year total 1.4, 0.1, 0.1, 1.6. And these numbers are given in millions. So all I did was go to the Excel spreadsheet and multiply by 1,000,000. And Duke had rounded where there was a 5, they rounded up. So instead of 1.4 million, it was 1.366 million.
Mr. Freeman, are you using this for illustrative purposes to ask your cross-examination questions?
Yes, Commissioner.
Okay, I'm going to overrule.
But before you rule, let me add one more thing. If that is what Mr. Freeman thinks the cover page does, his math is wrong. It should equate to the last page, which is 1.6 million.
You're testifying, so let's just ask that on redirect, okay?
Well, and that assumes that Dr. Morin, who had nothing to do with the data request, can answer any questions about this, but I'll try.
Okay, well, he can answer what he can, so I'm going to overrule the objection at this time.
Thank you. Dr. Morin, we were talking about the value of a basis point. And if you'd look with me at page 104 and also at page 404, those numbers in 404 are given in millions. Now we're talking about a 3-year multi-year plan, and the rate base goes up over the course of that plan. So of course, an ROE basis point has a different impact every year.
Correct.
And you can see that on page 404.
Yep.
That's the incremental increase. So that would be added on top of, if you look at 404, the rate year, the sort of base of 1.4. So rate year under page 404, rate year 1, 1.4 million, rate year 2, 0.1 more than that, so 1.5 million, rate year, the next rate year, 1.1 more, so 1.6 million. Do you see how?
I see that.
So what I did was, if you'll look at the first page, I did some math for you. You're welcome to bring a calculator.
I don't know if this, this has to do with my testimony, but go ahead.
I wanted to understand that when we talk about percentages and numbers, that we're talking about millions of dollars. And with a rate base as big as Duke Energy Carolinas has, that doesn't surprise you, does it?
No, not at all. It's very capital intensive.
You'd agree with me that a 1 basis point impact on the consolidated revenue requirement per the application over 3 years is in the range of $4.3 million.
That's what your arithmetic says, but
Okay.
this is unrelated to what I'm talking about.
Let's look at Duke's arithmetic on page 404. You see the 1.6 million there?
Yep, I do.
That's now we got to multiply that by about 3 to get to the 4 million, right? Because there's 3 years.
Sure.
Okay. If we could now look together to just see, sorry, I'm jumping around, Dr. Moore, and I apologize.
Oh, that's okay.
If you would look with me, we talked, for example, about, I think flotation costs were 20 basis points. That's $80, $90 million over 3 years.
Yes, that's about right. Ballpark.
Ballpark. If you look with me at Exhibit 25, which I would propose to mark as public staff Morin, direct and rebuttal, cross Exhibit 3. Am I correct?
Yes, it'll be so marked.
Thank you. Tell me when you're ready, Dr. Moore.
I'm ready.
These are responses to data requests, but I would ask that you please turn, I'm sorry. Yeah, I'd ask that you please turn to pages 5 of 7 and 6 of 7. And Duke will tell us that these are rough estimates. So they calculate to the decimal by Duke, but they are estimates. And you can see that the year one typical bill for 1,000 kilowatt hour residential customer of the typical bill of about $123, approximately $24 goes towards payment of the return on equity, and approximately a little bit less than $9 goes towards debt.
That doesn't surprise me.
Okay. Same pattern continues in years 2 and 3. Approximately a fourth of the bill is going towards return on equity and debt.
That's a huge component of cost of service. I agree with that.
And so again, we have real world impacts on people's bills when we adjust for return on equity.
Absolutely.
Okay.
Which the commission is well aware of, I think, of the affordability issue.
Yes. Equity is more expensive than debt, right?
Yes, because it's riskier. Bondholders are at the top of the food chain if there's any issues with cash flow or bankruptcy or anything. And then, well, no, I shouldn't say that. The IRS would be the first, and then the attorneys, Then, seriously, debt is senior capital. They have a first crack at the assets and cash flows. And at the food chain is equity holders. That's why people refer to them as residual claimants.
You would, in this case, debt is less than half of the cost of equity, right?
Debt right now, the company, if they were to issue bonds tomorrow, would probably cost 6%. And equity, if they were to issue, would cost 10.4.
Okay, we've settled the cost of debt in a settlement. So
yeah,
we could just compare that number to 10.4 and come up with. Yeah. And debt also has more favorable tax treatments.
Yeah, the interest is tax deductible. So
Not
6%, for example, would become 4% after tax.
Okay. And I guess one of the reasons that we want to set capital structure is because debt and equity have different values.
Different risks. I think what you're trying to get at here, I'm not sure, but it's the debt ratio. Where should it be? Should it be 40% or 50%? No?
I think that's Mr. Newland's territory, so
Okay.
I was just saying, when you're trying to get to the weighted average cost of capital,
Right.
you're going to look at equity times the ROE that you're setting, debt times the agreed upon cost of debt.
Exactly right.
And that's mathematical, right? Just the proportionate, multiply it out, and you get it.
Arithmetic.
And when we set equity, we do it for rate-making purposes in order to compensate the company, right?
Correct. Yes.
For example, you would not recommend that Duke Energy Carolinas have an 80% equity and 20% debt.
No, that would be an adverse consequence for the ratepayers. They'd be paying way, way too much.
There's some sort of seesaw where debt and equity intersect. And again, this is for Mr. Newland, not you, but there's a seesaw where they intersect, where it's the optimal capital structure.
Okay. Best way to explain this in layman's terms, the relationship between cost of capital and capital structure is kind of like a U-shaped function. As you increase the debt, it lowers the cost, lowers the cost, lowers the cost, but eventually you reach a point where that's offset by the increasing risk associated with debt, and it starts going up. So you got to be at the bottom of that U-shaped curve.
And so if we draw a line across the bottom of the U shape, so we capture the favorable part of the U, which is what the company and the ratepayer both benefit from, right?
That's correct. That U-shaped function could be called revenue requirements.
Yeah. 80% is bad in equity, but 0% is also bad. We don't want a company with that much debt. We're worried about it going out of business, aren't we?
That's correct.
Okay. The sort of bottom of the U is, can we say between 40 and 60% equity and 40 and 60% debt?
It's a little narrower than that. I would say somewhere in the, 48 to 53, 54 range.
Okay. Let's move on to another topic, which is, and I think we talked about it, but I'd like to put it into evidence. If you would look at exhibits marked as 16 and 17, these are average ROEs recently, 16 and 17.
Let's mark them one at a time.
I propose to mark 16 as public staff Morin, direct and rebuttal, cross exhibit 4.
Correct, 4.
And,
This shall be so marked.
and then I propose to mark exhibit 17, Morin, direct and rebuttal, public staff Morin, direct and rebuttal, cross exhibit 5.
It shall be so marked.
Thank you, Commissioner. And do you have the documents in front of you?
Yeah, and I'm familiar with both documents.
I thought you would be. This is a document from RRA that you looked at, and I went ahead and put in the data tables too. That's what the difference is in the two exhibits. This is a document that you reference and rely upon when you're doing this kind of work.
Yes, one of the many.
If you would, yes, if you would look with me, I'd just like to look at the data tables on exhibit 17. And if you would turn with me to page 5 of 10 on the document marked potential exhibit 17.
Yes, I have it.
So this is telling us that now I want to look at vertically integrated utilities, which is in the bottom of table 3 there. Do you see where I am?
Yeah, the 9.73.
Exactly. You read my mind, Dr. Morin. 9.73 is as of the quarter ending June 30th, 2023. The average allowed return on equity for utilities in the country.
So far, yes.
Okay. And we can actually see the quarter before, 9.7, quarter before that, year before that, 9.69. Do you see where I am?
Yeah, I do.
We have to go back to 2010 to get to 10.4.
Yeah.
If the nationwide average is 9.73, how are we at 10.4 for Duke?
Because the models indicate so. DCF, CAPM, risk premium, comparable earnings, they all indicate numbers that are much higher, which is not surprising given the steady increase in interest rates over this period.
Well, I think Mr. Jenkins put a case into evidence that just came out a few weeks ago that was 9.25.
Yeah, did you read the date on that exhibit?
I thought he said it was July, but I didn't.
No,
read it.
it's
I apologize.
2021.
I see.
Yes.
Um,
Different capital market environment now.
Okay. Duke competes against many people who want to invest capital, correct?
Yes, the way I explain it is utilities are in perfect competition for investor savings.
And so I've always thought that is a good reason to look and see what other utilities are getting allowed, because we do have to compete in the marketplace to get those.
Yes, you do.
So it just seems like 9.73 is an indicator of sort of where things stand nationwide.
Yeah, but that's an average. There's some below, some above, and it's a little bit stale, and the recent orders are much higher than that. We've
Okay.
got a lot of 10-1s and 10-2s in the southern utilities.
Another thing I sort of ask myself is, I feel like we have a better regulatory climate than, let's say, Arizona.
Like, definitely, most
We've got-
people do.
We've got HB 951.
Yeah.
Which has, decoupling, multi-year, earning sharings, PIMs, all that stuff. And we're not getting any credit, I guess, as it were, for being better than Arizona, because when you filed testimony in Arizona last month, you said it should also be 10.4.
Yeah, did you read the second part of that?
Well, that's what I'd like to have a discussion
Yeah.
today, and tell me why. I feel like we're just,
I describe my recommendation as extremely conservative for 3 reasons. Number one, they're still on historical test year. Okay. Number two, they have hardly any risk mitigators, unlike DEC and the DEP. And the third one is lots of disallowances in the past that were unjustified. They're they're the last in the country. And I told them that, and I think they heard me. The ratepayers are paying an extra 60 basis points on all the bonds they're going to be issuing in the next 5 years, let alone the cost of equity increase.
why wasn't your equity higher than 10.4?
Nice guy.
Well, I mean, each
I-
basis point is worth millions.
Yeah, I know, I know that. I guess I had in my mind the affordability issues and the rate shock issues, and I didn't want to go to, 11%. I just didn't want to.
Are you aware that there's a more than 20% rate shock forecast for the customers of DEC?
Yeah, I am aware of that, but the rate shock in Arizona will be far worse, I think.
Do we not want to say Arizona's worse than us? They're at 10.4. Let's come in a little bit lower.
No.
Why not?
Actually, the company was very concerned with the rate shock aspect, and even though I recommended 10.4, they filed for 10.2 as a way of easing the burden, the affordability issue.
They didn't do that in this. That's Arizona.
Yeah, that's Arizona. Yeah.
Duke Carolinas did not make a similar adjustment here.
No.
If you would turn with me to Exhibit 28, which I would propose to mark as Public Staff Morin, Direct and Rebuttal, Cross Exhibit 6.
So marked.
This is the response to a data request on pages 2 to 7, and then the first page was created by the public staff. This is
I'm sorry, Mr. Freeman, what's the potential exhibit?
the behind tab 28,
Thank you.
which we just marked as 6. You see on the first page, 29.25% increase.
Yeah, I do.
I just kind of want to, we're just better than Arizona, and yet we're not getting any benefit. You know what I mean? Help me understand that.
What do you mean you're not getting benefit?
Why is our ROE the same as theirs?
Yeah. There's a difference in timing too. That Arizona testimony was based on December 2022. That's one reason. And if I were doing it today, it'd probably be a lot higher.
Didn't you file it last month?
Yeah, but yeah, still based on older data, maybe March, if I remember properly. That's one reason.
Are there any other reasons?
I was concerned about this kind of thing, rate shock, affordability, and
Do you have similar concerns here for?
yes, I
Duke
do, yeah.
Okay. Does having those concerns make you want to lower your ROE?
No,
like
it
we
doesn't.
have?
No, I think the company's already taking some steps towards easing the affordability burden.
I understand. I guess let me phrase the question this way. We had concerns in Arizona. We have unfavorable laws, unfavorable recovery mechanisms, unfavorable jurisdiction. Still came in at 10-4, but you had concerns and the company came in at 10-2. Here we have a better jurisdiction, 29.25% increase. Does anything in you say maybe we should think about 10-2 being the correct return on equity?
It's in my range, the upper portion of the range, so I would not violently object to that.
Okay, thank you.
And there have been some orders recently in the 10-1, 10-2 area. Duke Energy Florida, Tampa Electric, and others, 10-1, 10-2.
I'd like to talk about flotation costs for a minute, if we could, Dr. Morin. We've talked about this. I think we just had some testimony, so I want to be very brief. But if you included in your recommended ROE, you have a 20 basis point.
Correct.
It's increased by 20 basis points to compensate for flotation costs.
Correct.
Okay. If you would look behind tabs 2 and 3, I don't know that I want to make these exhibits. We've gone over them before, but they're the North Carolina state law and just one example of the commission disallowing flotation costs. Maybe I'll just ask the commission to take judicial notice since we've spent some time on the topic. But I would like you to look with me at exhibit 29. Which I propose to mark as public staff, Morin, direct and rebuttal.
Mr. Freeman, what was that potential exhibit number?
I apologize. It was exhibit 29.
Okay, and you're identifying it as?
Public staff, Morin, direct and rebuttal, cross exhibit 7.
Okay, thank you. So marked.
This is the sort of official document that says, if you look, for example, at C, Duke Energy Corp does not intend to issue common stock.
I see.
E is even simpler. No common equity issuances are forecasted for 2023 through 2027.
I see that.
I understand your point about depreciation and how it should be recovered, but I just want to make clear that the company has represented that it will not be, item E, no common equity issuances.
Right. There are other ways to deal with flotation costs. Mr. Walters suggests expensing them, like cost of service. And I object to that because it would penalize current generation of ratepayers for capital that's going to last forever. So it's better to do it over time.
You might not be aware of this because I was not until recently that those expenses have been expensed before in prior cases. Docket number G5 sub 386 and sub 327, I believe, is where in natural gas cases. So not the same, but still accounting adjustments, not ROE adjustments.
If past flotation expenses have been recovered, my argument disappears completely.
Okay, I understand.
The only caveat I would issue is if you're expensing equity capital that's going to last forever, there's no maturity, it's going to penalize current generations for capital that's going to last and serve future generations. That's the only issue I have with expensing. But if they were expensed, then fine.
Well, I don't I think we all understand flotation, so I'd like to move on to another topic,
Okay.
but I don't want to cut you off.
No, I'm done.
Uh, Okay, the cynic in me, which I'm working on, but the cynic in me says, why is it that flotation costs are not baked in and you make a specific itemized adjustment, but North Carolina's favorable laws are baked in for which no adjustment's necessary?
What is the question?
Why is it, so I think that you would tell me if I asked that you have not made a downward adjustment to the ROE for Duke Energy Carolinas because of HB 951, the new law, HB 951. Am I right?
That's correct. I go by the correct financial theory. Every textbook in corporate finance allows for flotation costs the way I do it here.
I understand that, but let me just start a little more basically then. I understood from your prior conversation that you thought that the risk mitigation adjustment, the riders and whatnot, meant that basically the utilities were, from an investor point of view, fairly similar, and therefore the new law in North Carolina does not warrant a downward adjustment in the allowed return on equity for Duke Energy Carolinas.
Correct.
Then why do we make an upward adjustment for flotation costs? Why isn't that also just kind of how it's done and part of the numbers?
Because if the company issues stock $100 and investors want $10 of earnings, the company unfortunately does not net $100. They net $95. Got to pay the underwriter. So to get 10% return on $95, you need to earn 10.2.
I understand.
That's what the 20 basis points.
I understand the reason for the basis points, but can't we just say that this is already baked in? This is already how it's done, and therefore you have to adjust it.
Yeah, I've heard this argument many times. The problem is whatever the stock price reflects, if you issue common stock, you'll always net less than that. The equity account on the books is credited with $95, not $100. So you have to earn a little bit more on $95 to produce 10%.
Right. So
it's pretty simple.
Well, wouldn't you just issue the stock at $106-ish and make up for it that way?
No, then you'll net 100.
Right. And that doesn't work.
No, it doesn't.
Okay.
It doesn't work because obviously the investment bankers have done their evaluation, due diligence, and the stock is worth $100, not 106.
Dr. Morin, I would like to put several documents into evidence and discuss some topics about risk.
You keep looking at the clock.
Yeah, I'm just not sure. It's going to take a few more than 5 minutes.
Okay, well, let's end for the day then, because I have a few procedural matters that I would like to discuss before 5 o'clock. And so you may step down and we will see you tomorrow morning, Dr. Morin. So I would like to public staff has indicated that they want to file some supplemental testimony. And so tomorrow morning, right when we go back on the record, if we could be provided a list of public staff witnesses that desire to provide this supplemental testimony, and then a date certain when that testimony would potentially be filed. And so we'll do that tomorrow morning when we come back. And then again, the motions, they're just so Mr. Neal is prepared for tomorrow. It's going to be hard pressed. This is a different case than DEP, and bringing in DEP into this case with the numbers, the exhibit numbers, as well as substantive numbers becomes very confusing. So it could be that you want to really look at your cross from DEP and see what can be done, because maybe sometimes that's saved in the hearing room is not time saved after the fact. So in any event, but I'm not not necessarily prejudging if you feel like you can pare it down to where the commission does not have any concerns, but also be prepared for your cross-examination. And with that, we will go off the record today. And we'll see everyone at 9:30 tomorrow morning.